Good afternoon, everyone. It is Friday, July 31st, and summer is almost over, guys. L- I cannot believe how quickly time is flying. Come on in, say freedom now. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law. Welcome, McBean Immigration TV, Instagram, TikTok, Facebook. We're going to have a Q&A session here today, and we'll talk here and there about some news in the world of immigration. At 5 o'clock today, also Eastern Time, I have a video premiering on YouTube on McBean Immigration TV about how in the world did this happen, right? And in it, I detailed a really interesting story of a case that we worked on recently. And the client got his approval for the green card in 3 months after being in the US for 28 years. And in that video, I provide play by play. Literally, you've never seen a video like this from me before. Play by play on how it happened, what we did, all the evidence. I gave you everything in that. So watch it today at 5 o'clock. Well, after today's live session, of course, go back and watch it. It's good to see you. One of my colleagues, I'm very excited, is joining me today, Freedom Now. She's going to come in momentarily. Our managing attorney at our firm is joining me today to help with your questions. If you're enjoying having folks from our team join me on these live sessions, just let me know and I will be able to, I'll pull them in more frequently, okay? Type in Freedom Now where you're joining from today. We had a good call at noon with our plaintiffs. Okay. Someone says, thanks for all of the information sessions. Thank you, thank you, thank you. Thank you. Freedom now. Freedom now. Let's go. Someone is asking us to turn on the Russian subtitles. This session is being moderated by one of my colleagues. If he's able to do something like that, great. More power to you. Friends, we're here for you. 914-898-9488. You can reach out to us and book a consultation. You could also email us at info@mcbeanlaw.com to request a meeting with us. The phone lines are open Monday through 7 days a week. 7 days a week, Monday through Friday between the hours of 8 a.m. and 8 p.m. Eastern Time, and Saturdays and Sundays from 9 a.m. until 6 p.m. So, guys, let's get into your questions. What's going on with you? What's going on with your cases? My colleague, Attorney Carol, is I'm gonna just pull her up here. Hey, Carol, how are you?
Hi, good afternoon, everyone. Nice to be here with you. Freedom now.
That's right. Freedom now. You know what, guys? It's one thing to hear it from you, but it's an entirely different experience hearing it from members of our team. We feel it, right, Carol? That freedom. It's
That's
important.
that's right.
It is so important. So, Carol, before we get into the questions, actually, let me touch on briefly some news related to the 39 country USCIS policy. For those of you who are from one of those 39 countries, you have been following this issue very, very closely, as you know, my colleagues here at McBean Law and through the lawsuits that we're currently litigating. Um, we have been following the Dorcas case in Rhode Island that lifted the pause on the whole comprehensive re-review policy at USCIS, in addition to the adjudication hold policy and the other vetting policy that they have there. Um, the negative factors policy. And so the Dorcas case lifted all of that. The government pushed back, filed an appeal, and then filed a motion to stay the Dorcas decision, the judge's decision, and the appeal is still there, right? It's ongoing. The stay, however, was not approved by the court, and the government then took the case to a higher body. So the case currently is in the First Circuit Court of Appeals. And on July 22nd, the government did file an emergency motion seeking an administrative stay. And this is a 38-page document. I looked through some of it this morning, and in it, the government is making an argument that the court's decision in the Dorcas case was completely, of course, wrong, misguided, and it undermines national security. And so they laid out their arguments here, seeking an emergency stay of this issue. We're watching it. We're watching it. If you saw any of my videos or live sessions about Dorcas, you know that I think at some point this is going to potentially make its way to the U.S. Supreme Court for further review and action. So continue to watch and follow what's going on with Dorcas. Now, let's go into the first question, okay? Let's go into the first question. Let's go down here. Freedom Now. I see that Berlin, Germany is in the house too. Okay, we have we have some international folks here. Welcome. And then we have Atlanta, Georgia. Let's go down a little bit. Carol, are you able to see some questions in the app there on your end on the upper right side?
No, I'm not seeing
Okay.
questions coming in just yet.
Okay, so here, so I'll pull these up on the screen. Someone says I have TPS for El Salvador. TPS for El Salvador has ended. I have a pending petition for residency with my parents. Can I apply for a work permit, Carol, under the parent petition?
Okay, so so the question here is if you are the petitioner or the beneficiary, if it's your parent filing for you and you are an adult child, um,
Oops.
so so that question, so
Hold on a second. Hold on a second. We have a major glitch here. Give me a second, guys. Carol, can you still see the screen? I pulled up by mistake something here on the screen. This is hilarious. If I could just get it off. Not able to. There we go. Okay, so now the world knows that I play spelling bee on and New York Times. Yes, I do. I play the spelling bee game on New York Times. Thank God it was that.
so and you
Carol,
got the
go ahead.
correct spelling.
I did.
All right,
Yeah.
so if it's your parent who filed a petition for you, and you are in a category where you are not an immediate relative, and you are here in the United States, that application for an adjustment of is for adjustment of status. The requirement in that category, outside of an immediate relative category, will require that you are here with status, you have not accrued unlawful presence, and that you have not worked without authorization. So to qualify for a certain category where you are not an immediate relative, those are the requirements. So if that's your only pathway and you're waiting until you're waiting for priority date, you have a pending petition, just know that the requirement is that you must not have worked without authorization unless there are some protections that will cover you, like a 245I, which is a different topic for situations where you are in a category where you are not an immediate relative, just like being an adult child of a U.S. citizen or a green card holder.
Great. The next question is, and I'll take this one. Can someone in removal proceedings adjust status with an approved I-130 F3 category? So you're here in the United States in removal, and you have a pending petition or an approved I-130 family petition for being a son or daughter who is married of a U.S. citizen. You know, it's ending the process here in the United States is going to be the tricky part, right? If you're in removal, you might have an option to do cancellation of removal and get a 10-year green card through the court. But as far as adjustment of status, that's where I think it's going to be a bit harder to achieve because in order to adjust your status, you have to prove that you have continuously been here in the United States with lawful status. And normally, when folks are placed in the removal proceeding, in a removal in immigration court, they don't have status, right? And so that's the sticky point. But it is possible for some people to dismiss the removal case and have jurisdiction shift back over to USCIS for adjustment of status. We would need to examine your background carefully to see what's possible for you. But if it's through that F3 category, I don't see how that would work for adjustment of status. Let's see. Is there any good news, Carol, for DACA with regard to DACA? Or even the DREAM Act that has been reintroduced for for over 20 years, right? And then I'm going to shift it over to TikTok next.
Yes, unfortunately, we don't have good news in this regard. In cases, we've just seen, a recent renewal on the DACA application, but not so much as far as recent updates or really positive updates that can affect in general in this situation with DACA or in this situation.
Yeah, and I know we're still waiting on court action related to DACA. If you're joining on TikTok, double tap the screen, say hello, double tap, and Facebook, share this live session with your feed. Thank you so much for being with us on this beautiful Friday afternoon. Okay, here's a question coming in from TikTok. Let's see. My dad finished his last USCIS interview today. The officer will send him the response in a week. Is this a bad thing? I don't think it's a bad thing. I think that basically what we've been seeing these days is USCIS is reluctant to approve on the spot the I-45 adjustment of status. It usually happens days later or even some weeks later. Do not be worried. Do not be concerned about it. Hopefully your father will get through, but this is the recent trend that I've been seeing. Let's see. Uh, let's go up here on Instagram, and Carol, you'll take the next one on Instagram. Let's see. Let's go up a little bit. I'd like to know why USCIS accounts don't show the cases that have receipt numbers starting with MSC. Why I that this is not something I would ever know. But Carol, do you have a sense of why USCIS accounts do not
I
show
actually don't have an
cases?
answer on that.
Okay. So
That
I don't feel that bad.
but I don't know why it doesn't show up on USCIS accounts. I
Okay,
would think that there may be in I mean just like special treatment of really confidential cases, the VAWA, the humanitarian. I'm not sure if that has something to do with it, but just know that just like the change of address or the way that you would follow up or contact, there are like certain because of the confidentiality and just the type of case it is, and primarily for the VAWAs and the humanitarian cases.
could very well be that. Alice has a question here about, and this is from Instagram. Do we have any update? I'll take this one. Do we have any update on the 75 country pause or the lawsuit Clinic versus Rubio? So the Clinic versus, I'll start with that one first. Clinic versus Rubio, they're still waiting on a decision on their motion for uh, partial summary judgment. That case is pending here in New York, actually in the Southern District of New York. I don't know when the court is gonna make a decision there. In our case in Washington, D.C., we're working on our amended complaint and have met with our plaintiffs. We met with our 82, we have 82 plaintiffs in that case. We met with them this week. They've been cooperative, sharing their documents with us. We've been drafting additional declarations and working on their case. And then there is another case pending in Washington, D.C. that is on summary judgment, and they've been that case is fully briefed. They're waiting on a decision from the judge. There's also another case there in D.C. that had a preliminary injunction motion filed in March, early March, and the court has not made a decision on that preliminary injunction in that other case that was filed. That case was filed before ours. And then another firm, there's a class action actually that was filed earlier this month too in California. The class certification motion and preliminary injunction motion was filed last week in California. And lastly, I just became aware of another lawsuit related to the 75 country pause issue. It's really on the travel ban side of things, the 212F section. You know, folks are refused under the folks from the 39 countries, high risk countries, are refused of the visa based on 212F travel ban issues. There's a group lawsuit that was filed in the Western District of Washington, not Washington, D.C., but Washington State. And that one is pending. It's new. So these are all cases that I'm tracking. We're tracking here at McBean Law. None of these cases have gotten any decision. There is nothing meaningful out there that we could rely on quite yet. We're pushing, as you all know, and apparently I'm now responsible for the 75 country pause, as people have been texting me and telling me that it's my fault. I'm responsible for it. I put it in place. But anyway, there's a lot going on. There's a lot going on, and we're all from many different sides of the lots of different number of firms are really attacking this issue. So I will continue to keep you posted on what's going on with the 75 country pause. All right, thank you. Type in freedom now, double tap the screen. Double tap the screen if you're joining on TikTok. Thank you. Let's go to the next question here. Carol, maybe you could take this one. Arrived via Mexico border. Okay. I was released after being there for a few days, granted parole, which has expired. 8 months later, I filed for asylum at uscis, and I'm now eligible for a green card by marrying my U.S. citizen
Citizen.
spouse. So this person was paroled into the United States, applied for asylum. It's probably still pending, and now wants to do a
Mhm.
marriage case. What would you say about that,
Right.
Carol?
So we are seeing more and more USCIS really drilling down on the 212D5. So that's the argument, is that the 212D5 paroled into the United States meets the parole requirement. We have seen situations where USCIS really resisted on this and said that the parole that you had is not the type of parole. It's the other. It's a different type of parole and does not meet the inspected and parole requirement. So it varies per circuit, but generally speaking, there's really is an argument that this meets the requirement of inspected and paroled as far as adjustment of status. We are just seeing that some pushback from USCIS saying that it's parole but does not meet the inspected requirement. So there have been some approvals that where USCIS accepted it as an inspected and paroled, not uniformly applied throughout the
Mm-hmm.
different field offices. So, but there's really that argument that 212D5 meets the requirement of inspected and paroled, but expect some pushback from USCIS.
Oh yeah, definitely. Can I be comfortable while waiting for a response haven't submitted my I-539. I applied on May 19th and my J-1 expired June 30th. I was injured on my job and I'm actively seeking a doctor. So here's someone who was on the J-1, which is now expired. She was working and injured at that place of employment, and she's trying to extend her stay here in the United States. What would you tell her, Carol?
So the question here is the submission of the 539. Um, did it actually happen? So did it actually
It's either
happen
she's
before
trying
the thing?
to it's either she's trying to change her status, right? Maybe to a different visa type.
Mm-hmm.
I don't see how she would be able to extend it, but you're the expert in the room today. It takes a little heat off me, a little pressure off me. We have another expert in the room, so I could relax just a
So
little
the
bit. No, go ahead, Carol.
so if this is most likely a change of status, J1 to maybe a B2. Um, you know,
Could be.
so the important factor here is that the application for the 539 change of status, extension of status happens before the underlying or the initial status expired.
Okay, I'll take this one from TikTok. How long after the 4 years green card extension does it take to get a green card? So it sounds like you're going through the removal of conditions process, right? That's the extension you're referencing there. It's we've seen it happen, Carol. Some of our 751s, some can happen in 8 months. Others take 2 years, 3 years, right? Some go all the way up to the 4 year mark. It just really depends. What have you been seeing as of late with our 751s?
It's taking about two, I would say, 2 years, depending also on the basis. The waiver one, of course, tend to be a little longer.
Mm-hmm. Okay. Let's see what else we have here. It's taken someone is has filed an I-130 for his wife, and it's been over a year since the case has been pending, and the wife is from Canada. That's not uncommon that it would take a little bit longer than that for the I-130, even for a US citizen petitioner,
Right.
right?
If you ask USCIS, they will tell you 50 months.
How many months?
50,
50.
50.
You
Of
heard
course,
that.
that's not what we're of course that's not what we're seeing in real life for our cases, because as we track our cases. I mean, we even report about I-130s and 485s being approved in 3 months. But if
Mhm.
you ask USCIS, because they don't want you to keep on calling them, they say it takes 50 months for an I-130.
My husband is a U.S. citizen petitioner and applied for my I-130 in March 2024. He did biometrics last year. He did. Okay, let's start over. I'll start over. My husband is the U.S. citizen petitioner and applied for my I-130 in March of 2024. He did biometrics last year in June and was told we will be called for an interview, but it's a year now. We are still waiting. Can anything be done? So, if I'm reading this correctly, it sounds like the petitioner was called in for biometrics. Is that how you're hearing this as well? Okay.
Yes, that's what I'm hearing. Is the petitioner.
Right. And so normally the petitioner, well, during normal times, right, the petitioner is not usually called in, right, Carol, for biometrics unless there's maybe an Adam Walsh issue,
Exactly.
potentially. So they're doing, and it sounds like they'd like to do more background checks on your husband.
Yes.
She says that somehow you were told that they were going to have an interview. I don't know how that information got to you, who told you that there would be an interview, but it's been a year now and nothing else. It sounds like some vetting is going on behind the scenes by USCIS there. Anything to add to that? I don't know if this is the type of case that's ready for stronger action like a lawsuit. I'm not so certain that it's reached that point yet. We would want to learn more. If you were in a private consultation with me, I would, go a little bit further into your husband's background just to learn more about his history and your history, of course, and take it from there. We might even request some records if there was ever any previous immigration filings.
Exactly. That's a common that scenario where we see it when it's the U.S. citizen petitioner called for an interview. It's an Adam Walls issue or some type of criminal history, and they just want to verify. The other possibility is also questions about previous filings by the U.S. citizen.
Right. Can a visitor's visa from 75 countries be given only 3 months today to visit, apply for asylum, and get a work permit? This is a trick question. Trick question. There's a twist to it, right? So, the visitor visa, of course, if you're from one of the 75 and you have a visitor visa, you can certainly travel to the United States on that visa. Now, you have to watch your intent here, certainly, because towards the end of your question here, it sounds like your intent is to come here to apply for asylum and get a work permit, which is the wrong intent when you're coming here on a visitor visa. So that's where I think you've got to watch what you're thinking there. Okay. All right. Carol, you want to take this one about an I-485 adjustment of status application. This person says that there's a criminal case.
Mm-hmm.
Um, Criminal case started a waiver was filed for
A waiver.
inadmissibility ground before getting a second interview or wait to receive it. I'm not certain whether the entire question, whether this makes sense to you.
Yes, I'll take this. So when you apply for a 485, there's already that question about have you ever been arrested, cited, charged, convicted by law enforcement? This is the time when you really need to speak with an immigration attorney to have that initial assessment. If this is the type of if you answer yes to that, and if this is the type of crime that makes you inadmissible, that will require a waiver.
Okay. And Carol appears to be
The
frozen there.
time. Can you hear me okay?
Yes, you were frozen there. Go ahead.
Okay.
Her employer
So
needs to
if this is
upgrade the system there. You were
that's true.
frozen. You're in and out.
So anyway,
Go ahead.
okay, what about now? All right.
Yes.
So so it would need you would need to speak with an attorney to make a determination if this crime is that needs a 601 waiver. Currently with the I-45, and hopefully this will save you time if it's determined that it's the type of crime that will need a 601 waiver.
I have a VAWA case that's been pending for 3.6 years. How close do you think I am to getting a decision in the case? VAWA, I think, is 3 to 4 years now on that application process. Double tap the
Yes.
screen, friends. Thank you so much for being here on this beautiful Friday afternoon before you end your workday, go out for drinks or whatever you do on Friday evenings. Join us for this live session. I'm with one of my colleagues from our office. Green card holder had a misdemeanor, not convicted. It was dismissed. Can I apply for naturalization? My opinion on the matter is that with naturalization and a criminal record, you should speak one on one with the attorney of your choice to determine what happened and how it could potentially impact you. I
Exactly.
really like the fact that you tell us that you weren't convicted, and that's great. It was a dismissal, but sometimes folks don't always understand whether a case was dismissed or not, right? So an attorney will need to review the criminal disposition, which tells us how the matter ended. and confirm whether it is a true dismissal and what the implications are before you apply for naturalization. If you're eligible for naturalization, friends, definitely go for it. Now is the time for naturalization. Still, it's just that you have to be cautious when you have a criminal record. All right. Any idea, Carol? Carol is one of our consular experts. Any idea when will the pause be removed from Pakistan? The long distance has now been more than 2 years for us, and I have my interview next month. And how much longer do I have to wait for my visa after the interview? So here you have Pakistan, which is part of the 75 country
But
ban, right? Do you want to take this one, Carol? Um,
so,
this person says that I have my interview next month.
so directions yet from the Department of State as to what happens when the pause is lifted. So what we know
Can
is
you
that there
repeat?
is
Can
going
you
to be
repeat that, please, Carol? Say that again.
okay. So we don't have instructions yet or directions from the Department of State as to what happens after the pause is lifted. So in terms of instructions from the Department of State in terms of what happens post interview or the issuance of the visa when the interview has already happened for those that already had their interview and for those like you that are just about to have their interviews. We don't have the instructions yet as to what happens in terms of issuing the visa once the pause is lifted.
Right, but what we do know, based on experience, is that these folks are being placed in 221G, administrative
Mhm.
processing, and typically what happens when an individual is released from that phase is it depends on how long they've been in it. If they've been in it for several months or longer, the embassy will ask for certain fresh evidence to be resubmitted to them,
Mhm.
right, Carol? Like medicals, police clearance, but the embassy will make that decision and issue that letter to you if they need new, fresh records from you. As my colleague said, we don't yet have any clear guidance from the embassies that are unfortunately placing all of these pretty much approved people in that 221G bucket because there's no inadmissibility problems found with them. We don't yet know how they're going to run these people through the new screening tool around public charge that they've promised to be developing. We don't know what those
Right.
instructions will look like. We don't know what the criteria will be. We don't know anything quite yet, which is why litigation is so important. We want some disclose. We want to know what's going on. We want to know what's going on and when they're gonna, really lift the pause so that you guys would not be separated from your family. Okay, thank you. Double tap the screen. Thank you guys so much for being with us today. Let's go down just a little bit here. I know I did see a super chat question come in. I'm going to add the super chat. This is the first super chat question today on YouTube. Thank you, Leo, for your super chat. He says that I'm a DACA recipient and I would like to do adjustment of status through marriage. I have lawful entry. Great. I have no criminal record and I'm having trouble finding my I-94. Can you find mine with an A number with no, can you file? I don't know what he means by the last part here. Can you find mine with an A number with no passport? I think the big point here is how can he prove lawful entry when
Lawful.
he doesn't have the I-94? He might have lost his passport. Carol, what do you have to say about this?
So the electronic I-94 started around 2013. Um, for the paper I-94, if that's what you're looking for, I would actually recommend FOIA request. And there's also that I-102, which is the to request for the replacement of an arrival departure record.
Okay. And then, okay, the Form I-102, right?
Correct.
Okay. Now,
But of course, we need to provide information to in connection with this I-102 related to his entry.
okay, that's right. Thank you for the gifts on TikTok. I appreciate it. Thank you so much. Can I use my travel permit? What are you advising new clients and even clients at McBean Law these days around traveling with advance parole? What are you telling them, Carol?
Please don't travel as much
She
as
said it so
possible.
nicely. She said it so nicely. Please, guys, please, please. We're begging you. Carol is begging
Because
you.
we
Whereas I
see what
say you're doing
happens.
it at your own risk. Yeah,
Ayun.
it's a terrible time. We're seeing some things
Yeah.
that we've never seen before, Carol, with travel. So Carol's global advice is not to use advanced parole.
Because we there were situations where they were told to go back to your embassy and sort it out with the embassy.
Carol, do you want to talk
So,
very briefly about VAWA? Because VAWA
yes,
applicants who have a pending application and advanced parole traveled and tried to get back into the United States, and some of them are stuck outside of America today. What's going on there?
exactly. So, especially for those who's had their work permit and advanced parole combo cards valid until 2029, valid until 2028. You've been so used to traveling back and forth and nothing happened, and the way you receive your advanced parole pending VAWA application, heard of really investigations related to fraudulent VAWA applications. So they are really hounding on these types of applications that now results to some denial of pending VAWA applicants coming back into the United States and they're being denied entry. And this
Hmm.
is a situation where you have a VAWA application, you have you're traveling on advanced parole based on a pending VAWA, and we're finding that they are being told we can't let you go back and go to the embassy and sort this out with the embassy. And then we've had consultations where they actually went to the embassy, explained the situation, and then we're told go talk to an attorney. And so you don't want to find yourselves in.
Exactly. I'm a U.S. citizen. I receive SNAP and Medicaid. I have a joint sponsor for my fiance. Will he be considered a public charge? Because his fiance is receiving public benefits, Carol.
So it's they don't look at the U.S. citizen as far as the public charge. The upcoming public charge rule, they are going to look at the totality of circumstances. So they're going to look more into the applicant. So what we're seeing is in addition to the joint sponsor, then they're going to look at the other factors related to the applicant as far as the age, the health, employability, credentials, educational credentials, the background. So that's what we are anticipating is going to happen, especially with the upcoming public charge rule that's going to come up in September. But the benefits that you get as a U.S. citizen, and I don't think that it counts as far as the public charge is concerned, as long as you meet the income requirements or you have a joint sponsor, and in addition to the assessment of the applicant, meeting the public charge totality of circumstances scrutiny or
Do green,
review.
I'll take this one. Do green card holder spouse currently in the US leave the country for visa interview after the I-130 is approved? So the way I'm understanding this is the petitioner is a green card holder, and the question is whether the spouse need to leave the country for a visa interview. That's how I'm understanding this question. So, if the spouse, the green card holder, does not become a U.S. citizen, then most likely the individual will need to leave and consular process. But it all depends too on whether the priority date, whether the category F2A was current at the time of filing and some other criteria is met, right? Then that green card holder spouse could actually adjust the spouse could actually adjust status in the US, right?
That it, I agree. If all the requirements are met as far as not accruing unlawful presence, in status still, no work with authorization.
Question. This is a question from TikTok. I applied for EB3. I grew up in Canada, studied in Canada, but I'm born in Jamaica. Does the freeze affect me? Yes, it does because it's a nationality-based policy. So it applies. It doesn't matter which embassy you're applying through, so to speak, or being interviewed at, so long as you show them that passport showing that you're Jamaican, a Jamaican national, then they will, unfortunately apply that pause um, to your file. Thank you. Let's go down a little bit here. Um, Can my therapist counselor fill out my N648 and then my clinical psychologist sign it? I have severe PTSD. So this person is asking whether her counselor can fill out the N648 and then have the clinical psychologist sign it.
So usually it's the primary care doctor that fills out the N648. What you need to show in this 648 is that you have this condition that's preventing you from learning English and the civics, and that condition goes for like more than 12 months. So there's like some type of permanency. And that's what needs to be shown in this N648. So if you can argue that you have been seeing this doctor consistently and is the authority or the reliable person that can say, this is the condition that's preventing this person from learning the English part and the civics part, then that's what USCIS will accept.
Terrific. Freedom Now, guys. If you're now joining, today at 5 o'clock, we had a video premiere on McBean Immigration TV about steps that we took, play by play, involving a case of our client who got his green card in 3 months. If you have a good case before USCIS, it could result in a favorable outcome for you. Some cases are now starting to move faster, which is great. It really reminds me, Carol, of like the Biden era, so to speak.
Yep.
Although that our client had an interview, they are calling in most couples for an interview. But in the video, we talk play by play. So you want to catch that video later on tonight. All right, thank you. Let's see if we could just take a few more before we wrap up our Friday afternoon. Okay, so this individual says, I have a pending asylum case. It was administratively closed, dismissed without prejudice. Can I renew my EAD or do I need to reopen my case in order for me to be able to do that? But so my understanding, though, is that if this administratively closed VAWA case, I'm sorry, asylum case, is before the immigration court, you could continue to renew your work permit, right? But then this person says, well, there was a dismissal. If there was a dismissal, well, then no, then you're no longer able to keep going with the work permit if there was a dismissal. Let's go that because that means you no longer have a pending application before the court. Let's see. I am a US citizen and I have a 26-year age difference. And I'm on Social Security. My spouse and I are waiting on the interview. But can these reasons be a cause for denial? The age and the financial situation, Carol.
So the age, it's not it's not because of the age difference that causes a denial. You really have to show the bona fides of the relationship, how authentic this relationship is. As far as the financial part, they look at so there's that income requirement, the threshold. So, if you're receiving, Social Security, it depends if you were required to file taxes. That all depends on, the income from last year, current income, the Social Security statements and earnings that you can show. Those will be the reasons that those will be the things that they would look at, and it's not because the age difference or just Social Security income. Those are not reasons, outright reasons for denials.
I would like to know if you have any consultation slots available at the moment. My wife and I would like to book a consultation. We currently live in Europe. Our concern is finding a time that works. My apologies. I did not pull up our availability to share with you today. I don't know if our moderator can do so while we're on this show and just type in when I'm available and when other attorneys are available. Carol, I don't know when do you know when you're next available? Um,
Yes, I don't have my
the
information, my
calendar in
next
front.
availability, yeah, the calendar in front of me.
But just call the office and just ask, and one of our colleagues will be happy to give you that information. I know that tomorrow morning I have three consultations on this Saturday morning. It's been a little bit since I had Saturday consultations. But I do have three tomorrow already booked, and I think next week and the following week, I believe are booked up for me. But my other colleagues are more readily available, of course. Thank you guys. Double tap the screen. Thank you so much for joining today. I hope you had a terrific Friday. How long does it take for the N400 interview to be scheduled in Sacramento, California? Um, Carol, I don't know if you have any data in your mind on Sacramento, California, naturalization. Naturalization, generally speaking, takes about 8 months to a year, generally speaking.
Right. I don't have the information for Sacramento, but yes, that is. I mean, we've seen naturalization, really being processed and interviews scheduled within 4 month mark, 5 month mark, through eight on average, I would say, across the different um, field offices.
Freedom now, freedom now. I'm gonna address this one here. Someone says, let me go back to it. Why is it that after paying you guys, nobody um, cares about trying to speak, something about trying to speak with an attorney for 2 months now? Why is it that I can't do that after paying money? I didn't have to pull this up because obviously we have a lot of questions on all forums, and I'm not answering everyone, but I will answer this. So first of all, if you're a client of ours and you have your concerns, there's a way of doing it. You could contact the office. You could ask to speak to Carol. You could ask to speak with an attorney on your file, or you could email us. We're reachable. Now, the some cases come in and they're case assessments, which means that we're requesting records from immigration and we're waiting for immigration to send us your FOIA records. And while we're waiting on that, there is a little bit of a silence. We're waiting on your records, and then we'll schedule a meeting with you and go over what we found on your record, what it means, and what your next steps are. I don't even know the details here. I'd love to know the details. Write us, send an email, send it to me. Send an email to info@mcbeanlaw.com to my attention. I'd love to see what you're referring to so that I could speak with Carol and others on the file. And actually, when I saw your message, I did share it with Carol and some of the other managers, I think yesterday. But we don't know who you are. Here we are talking about you. We don't even know who you are because you hadn't done this properly. So tell us who you are and let us get to the bottom of it. Happy to help you. Okay. Happy to help you. Let's keep going. Let's keep going. I filed my I-130 for my Ghanaian husband who is in removal. Had an initial appearance. His attorney pled guilty to it's not really pleading guilty to unlawful presence, so to speak, but I understand what you mean. His attorney pled guilty to unlawful presence and asked for continuance of removal instead of dismissal. Is that common? Okay, so here you have someone in removal at the master calendar hearing. The attorney did acknowledge that, yes, this person is present in the United States without status. That's very common. There's nothing wrong with that. And then the lawyer asked for more time, I guess, to prepare the case, so continuance instead of dismissal. Asking for dismissal is a strategy that the lawyer has to develop, right, based on the circumstances of your husband's case. Um, and I don't know whether the judge did grant the continuance or not. It's harder these days to get continuance on these removal cases because immigration is really trying to force people to the end of the process. But I don't really see anything wrong here based on these facts um, at all. We're happy to give a second opinion if you'd like, privately, so that we could learn a little bit more about the removal case. Someone said they had an interview earlier this week. Great. We wish you well. Double tap the screen, friends. Thank you so much for being with us today. I'm with one of my colleagues, Attorney Carol, a managing attorney at our company. And she is on YouTube with me and Facebook. Carol, someone on Instagram says, if I'm being filed for by my mom as an unmarried adult, does it make sense applying for a B1, B2 visa at this time if she has an
So
I-130?
if she has an I-130, that all depends on the reason why you would want to file a visitor's visa and really convince the officer that your stay here is temporary. So it's not a blanket, just because I have an I-130 file, it's pending. We consular officers, we know that the F1 category can take it. They're processing what, 2016 right now, so it takes a long time. So it's really a matter of convincing the consular officer that my purpose of visiting now, that's why I'm applying for a B2 visa, is temporary and it is for this specific purpose.
Mm-hmm. Okay. Why is it taking so long, Carol, for some immigrants to get a decision for their adjustment of status?
So it takes long for some because there's more vetting, more review that USCIS officers need to do. They might, depending on someone's history, there might be previous filings. There might, have been denials at the embassy prior to coming to the United States. So there's a whole lot of background check and investigation, and those are is one of the common reasons why some I-45 adjustment of status applications are taking longer, more so than
Mhm.
others, like the straightforward ones.
Okay, citizen mother filed an I-130 for unmarried daughter. The application has been approved. NVC has now sent a notification to pay the fees. I'm in the United States, however. Can I just do adjustment of status now? So it depends on whether you're here lawfully, right? If you're still in lawful status, that is the key to being able to transition to just do an adjustment of status. And the fact that you did not work without authorization while here in the United States. So your priority date has to be current, of course. No work without authorization, and you might be able to adjust, but it's a delicate process. You certainly want to consult with an attorney before you try to transition to adjustment of status. Thank you all so much for being here with us. We have a lot of good questions in front of us today. Thank you. Thank you. We did address the 75 country pause. I provided a detailed update on that. You could watch the replay on YouTube, on McBean Immigration TV. My husband had an I-130 interview in January here in the US. When can he expect a response, Carol? Carol
Um,
knows everything. She
so
has the crystal ball. When will
so
Laddie when when can Laddie get a response?
so these are, I mean, it depends on several factors. Where is the beneficiary from? Was it part of, was the beneficiary happened to be part of the 39 country pause where they're just now, um, you know, some decisions are approvals or decisions are trickling in. But I would norm also, it depends on what type of I-130. So if it's an immediate relative, I guess I have more questions as to whether an adjustment was
Yeah,
filed.
there's
But
more to learn. There's a lot more to learn
there's
for
more to
sure.
learn than just say if you had your interview in January, you should expect a decision by now, because it depends on what else went with that I-130 application. Was there an I-45? But one thing that I'll park you with is, if they do need anything, they will send you an RFE, request for evidence, to help them make a decision on that case. It is also very much possible that more vetting is being done after your interview, depending on what the answers were at the interview.
My brother was arrested by ICE last month. He had a deportation order since 2006. Can something be done for him? He has an approved I-130 and he's married to a US citizen. So in a consultation with the family member, first of all, we do take, just so you know, we take emergency appointment requests. So in this case, it would be considered an emergency. This person was arrested by ICE and facing deportation. So we would look to see whether a motion to reopen can be filed for him. We would also consider an emergency stay, maybe a habeas if a habeas is necessary in this case. So we would go a little bit deeper to learn more and then determine how we might be able to, what service we could offer to him. Uh, Carol, does the pause affect immediate relatives of U.S. citizens?
If we are still talking about the 75
I'm
country
assuming,
pause,
yeah, I assume that's what this
yes,
individual is referring to. Yeah, it does. Unfortunately,
it does. Yeah.
there's no exception under this awful policy.
Okay.
Let's go down. I'm asking that you please do not spam us. If you've asked a question, please just ask one time. Thank you. I filed for asylum in June and I've already done my biometrics. Is it true that nowadays we'll get the interview really scheduled really fast? So, and Veronica is asking this question. Asylum is going through an overhaul at USCIS. They're changing everything. They're trying to, for some cases, under a new rule that I spoke about earlier this week, they are looking to bypass the interview process and immediately place individuals into the removal system who had applied for asylum after the 1 year deadline had passed, and some other people they're looking to target. So that's one thing. But there are millions of applications, from what I understand, pending or asylum applications. But now, as far as interviews being scheduled fast, yes, I have seen some people, right? Those who had parole, one of those humanitarian parole or even TPS, try to transition to asylum, and then things happen. One, two, three interviews were scheduled like the very next month. So it is happening fast for some people. Why? Because they want to immediately shift folks to the removal system, not because they're giving you a fair chance to lay out your case before them. It's because I think the intent is just to shift folks to the removal system. Thank you for being here with us today. What is the cost for a straightforward marriage-based green card? So, Carol is a new guest to our show. I'm not going to turn this question over to her because she probably doesn't know that the policy that we never discuss fees live like this. You need to have a consultation. Why, Carol? Consultation is needed first to determine attorney fees, of course, because we have to learn more about your background and the case and what your history really is. And we'll quote you the fee in a consultation. My son's I-130 got his second interview in Addis Ababa, Ethiopia. So, what do you think? A second interview at the embassy in Ethiopia, Carol? There might be an
So yes,
issue there might be an issue though with regard to the bona fide relationship, parent-child relationship,
you
right?
right. Second interviews are usually when they want to verify something. Depends on like the relationship, the birth certificates, the civil documents. Especially if you have birth certificates that are late registered. Those are some of the common reasons why for a parent-child petition that there might be more than one interview, or the child is called back for another interview.
You know, what's funny about some of these questions, Carol, I don't know how these people, they might have just looked you up. I don't know. I never get questions like this on my regular show. All of a sudden, I have the counselor expert on the show, and I'm getting all these questions, right?
Questions.
Here's another one. I'm from the DRC, and my case is part of the executive order 14175 pause. The NVC approved my case in May, but the U.S. Embassy in Kinshasa
Kinshasa.
is closed due to the Ebola outbreak. Should I request that my case be what moved, or what is she asking here? I'm not. He's asking. Miguel is asking.
So yes, you'll also have to remember that when you request to move a case from one jurisdiction to another, there are certain requirements that you have to meet. Just like you must have status in that, some type of status in that new embassy or
And
consulate.
Carol, I'm sorry to interrupt you, but here's the second part of what he is asking here: whether he should transfer the case to another embassy, such as Nairobi, or should he wait?
Nairobi. So if you have basis to transfer to Nairobi because you have some type of residency there, that's something that you can request to transfer. However, if it's a situation where you do not have permanent resident, or you don't have some type of legal status in Nairobi, for example, and it's not a situation where you can just request to transfer. Usually, in situations when there's political chaos and the embassy is just not able to operate, usually the Department of State will give instructions that applicants from this embassy should go to this embassy now. But as far as making your own request, one of the requirements is you have legal status in that new jurisdiction, and then you make the request, and then when it's approved, you're assigned a new case number
Is it
specific for
safe?
that new embassy.
Is it safe to travel on the 751 extension letter? You probably you might not have been around earlier when Carol said, "Please do not travel," but that was with regard
Advance
to
parole.
advanced parole. Here you have someone with the I-751 extension letter. What would you tell him or her, Carol?
751 extension letter, you are a green card holder. As long as you have that original copy with your expired green card, you're safe to travel for as long as there are no other issues that you're concerned about, like a criminal issue, or anything that will make you, anything that can flags as far as your immigration history. But it's safe for those with 751 extensions because you are, you know, permanent residents, just conditional.
Hmm.
for as long as you have the green card and your original copy of your immigration letter.
Any update on TPS for Haiti? So the E-Verify, the department, the government sent out an email under the E-Verify system, which is a system to verify employment authorization that companies use, employers use. They did send out various emails this week informing employers of the court's decision with regard to Haiti, South Sudan, and several other countries to notify them of when the work authorization end date is. And so for TPS for Haiti, the work authorization ended earlier this week. I think it was the 27th, if I'm not mistaken, Monday, if I'm not mistaken. So that has ended. That's over. There are various social media videos being done by government officials, including the DHS secretary, talking about TPS ending and your stay here is over and you've got to leave. So they are building, obviously, they're building towards trying to deport, right? But I have a lot of resources out there about what your options are if you have any options. Some people will be placed in removal, and some people will have options while they're in removal. It could very well be an open door for some people to seek maybe cancellation of removal. Asylum is not the default. Get your case evaluated carefully before you try to apply for asylum. Others have family-based options that they could, potentially pursue. And we have been getting a good number of consults from Haitians who are seeking, advice. And we've been telling them the same thing that I told you today. Let's see, Carol, I am an American. If my fiance and myself got married, how long after can we file the case? Mel is asking.
Well, if you get married, this is going to be an I-130 petition. There is really no wait as far as when you can file. The requirement, the trigger, of course, is that you have your marriage certificate and be able to show your bona fide marriage, your bona fide relationship.
Yeah, I usually tell folks that, for instance, they might have been together for 5 years, right? They might have a real history together, in which case there's really no need to wait with regard to the filing. But for some others who are fresh in the relationship, you really don't have much of a story to tell quite yet. Be careful with filing so early because nowadays, filing a bare bones marriage case is not a great idea. Not a great idea at all. You want to have some real good evidence of the bona fide relationship. I'm so stressed because of the pause. Please tell me, when is it going to be lifted? Any chance for it to be lifted this year? I I personally, through my own the work that we're doing, we really believe that we will get a decision this year based on what our judge has told us about an expedited summary judgment schedule. There are several other lawsuits out there. Some are ahead of us, right, waiting on court decisions. And so I do anticipate that some of these cases will get a decision this year. But I don't have that crystal ball to say when the pause will be lifted. All right. You guys have great questions today. Thank you so much for being with us. Let's see, Carol, if we could take maybe one or two more. I'm married and my wife left me. What would happen to my filing now? Um, can I still get a work permit? This person said he is married, wife left him. I don't know what kind of filing, if they have a I-130 case, an adjustment of status with it. I don't know. Can I get my work permit? Basically, the relationship has broken down, right? And there's a filing out there, and he's concerned about the work permit.
Well, if the work permit was part of the filing, there is still that. possibility that it's going to be approved because it is, I mean, a decision will be made on that because it is pending. But then, in terms of the actual application, that all depends on the relationship of your wife. I mean, realistically speaking, couples do get back together.
Oh, is
So
that what
you may not,
happens sometimes?
sometimes.
And when immigration is
So,
part of the equation?
so,
It does
unless it's,
happen. It does happen. Go ahead, Carol. I'm sorry to cut you off. They
so,
couples do get back together, counseling. You could see counseling. What I'm most concerned about, actually, in a scenario like this one, it has more to do with, well, what's going to happen when you get an interview notice? Is that spouse going to, are you back together for real? Right? Are you back together in marital unity at that time? If so, great. It's going to work out for you. You'll be approved. But it gets really tricky if the relationship is still rocky and there's an interview that's on the table. And then also for us, we would assess whether we need to transition the case, if it could be transitioned to something else like VAWA. If there is a VAWA case, we would assess for that as well so that you could continue on your own.
but to answer his question, if there is a pending I-485 application, then
Mm-hmm.
usually because it's pending, there's a 765 work permit, still being processed or adjudicated related to the pending I-485.
Right, exactly. Can someone still apply? I don't know. Here I am in my podcast room, right? In my podcast room, the cleaning crew, they're here, and the guy could just look through the window and see that I'm in here, lights on. Like, shh, go to the other side of the office and vacuum, not back here. But he made his appearance here today. Can someone still apply while visa overstays? So nothing has happened to change the qualifications and the categories with respect to applying for a green card or any immigration benefit, despite the fact that an individual had overstayed his or her visa. Okay, Carol, I'll let you take this last one so that we can start our weekend as well. Thank you all so much for being with us today. Um, Carol, I'll let you handle this one. Are you saying that if a Jamaican citizen who is now Canadian got married to a US citizen, he will be affected by the pause because he is from Jamaica? Or since he is now Canadian, it will be okay. Now, there's the dual citizenship exception here that needs to be mentioned. But Carol, how would you respond to this?
So yes, compared to the earlier question, this question here is referring to you being a dual citizen. So if you are going through the process using your Canadian passport, then when you go for your interview in Montreal, then it follows that Canadian passport is not subject, even if you're a dual holder, because you are using, they go by the passport used. So if you're using that Canadian passport, being a Canadian citizen, then this exempts you from the 75 country pause.
And with that being said, friends, thank you so much for joining us today. Thank you to my colleague Carol. Before going live, and she is when I say busy, I mean busy, busy. And I text her. I said, Carol, can you go live with me? And she, without hesitation, said, okay, what's the topic that we're going to talk about today? Carol, she did not say, "Oh, I have all these things to do. It is Friday afternoon," and she could have said something else, guys, but she didn't. So, Carol, we really appreciate having you here with us today. You added tremendous value to the discussion, and we will have her back. We will have her
Thank
back.
you all for joining us today.
Yes, exactly. Friends, we're here for you. You can reach out to us at 914-898-9488. Our phone lines are open until 8 o'clock p.m. tonight, Eastern, and then also Saturday and Sunday between 9 a.m. and 6 p.m. Eastern. Just give us a call to schedule your appointment, or you could email us at info@mcbeanlaw.com. Have a wonderful weekend, and I will see you on Monday at 1 o'clock p.m. Eastern Time for our usual Freedom Now show. Have a wonderful weekend. Bye bye.